accused company normally assembles and sells. The agreement was that the complainant company will be paid in terms of the weight of each individual item that has been delivered. Your Honor, upon the delivery list being provided to the complainant company, it went back and checked its manufacturing specifications, which provide for, among other things, the weight of each individual item in the size. And the accused part, the company came to the conclusion that it owed a sum of 183,017 shillings. The accused person being a director of the city of 183,017 shillings. Your Honor, the accused person being a director of the said company has proceeded to draw up a check in favor of the complainant. Which check has not been picked up and is still in the custody of me, myself, the advocate. Your Honor, from the facts that have briefly deponed, it only raises two issues, in my opinion, for consideration. The first being whether these charges can be sustained by virtue of them being a debt collection matter which will be handled in the civil realm of the justice system. Your Honor, under Article 157(11) of the Constitution, the office of the ODPP is given its prosecutorial mandate. The same article states that it must be exercised in good faith, guided by public interest. Your Honor, I know I put a lot of emphasis on public interest, and in a manner that upholds the interest of justice. Your Honor, but the face value of this matter, it is simply a civil dispute which proper jurisdiction should be in the civil court. Your Honor, I'll also point out the court's attention to the national prosecution policy, which was revised in 2015. Under page 5, Your Honor. Your Honor, it states that the public prosecutor, in applying the evidential test, should objectively assess the totality of evidence, both for and against the suspect, and satisfy themselves that it establishes a realistic prospect of conviction. Oh, I apologize, Your Honor. Perhaps I can just make a reference to my written submissions, just avoid regurgitating. Under paragraph 22 of my written submissions, I have made reference to a case that was decided by your brother, J.V. Odunga, from paragraph 83 to 87. Your Honor, your brother J.V. Odunga in the same paragraphs goes deeply into the issue as to where parties simply want to unjustly enrich themselves or to use the criminal justice system to achieve personal vendetta. And Your Honor, particularly, I'll draw you to a case that he has quoted under paragraph 86, being Gilunguri versus Republic. That's a 1986 case, where under page 22, line 22, the learned judge at that point stated, a prosecution is not to be made good by what turns up. It is good or bad when it starts. And Your Honor, it's a very clear forward matter. A company offers services to another company, an invoice is raised, the invoice is partially admitted, and Your Honor, a matter is reported to the police station, which is simply a civil matter. Furthermore, Your Honor, I note that in a criminal matter, the burden of proof is beyond reasonable doubt. Your Honor, should the complainant think that she can meet this threshold, then it should be easy to meet the threshold in the civil case, in a civil matter, which is on a balance of probabilities. Your Honor, lastly, on this point, I will note that the matter is under 1 million shillings, so it should be within the realm of the small claims court. And the fastest and more justiciable way to follow up with the matter will be in the small claims court, which jurisdiction does not extend beyond 60 days. And Your Honor, should all debt collection matters from the small claims court be brought to this court, the criminal court will be overwhelmed. And I'll just give an example. I filed a matter in the small claims court for a client as of last week, and we're already at number 97,365, while being halfway throughout the year. It will be a nightmare for judicial planning. And Your Honor, even in the country, Your Honor, we have had instances where there is a lot of bad faith from the public, where it is believed that the office of the ODPP continues to prefer charges in matter simply civil. Your Honor, I've raised this also before in this court that even the reason that we are sitting in the premises of Kibera law courts is that the premises of the Agglutinative law courts were destroyed in a protest that was tied to an allegation that was made for defamation, which is simply a civil matter, which led to the death of one individual by the name of Albert Ojwang. I say no more, Your Honor. On the second head of argument, Your Honor, Your Honor, the accused person is a director of a company, an incorporated company, being Kryptonite International Limited. Your Honor, a company does not have the limbs to action or act on its own behalf. It simply relies on the directors. This is one of the fundamental, a locus classicus, Your Honor, I would say, when it comes to issues of corporate law. Your Honor, I can go on and on about cases such as Salomon versus Salomon, Lee versus Lee Air Farming, Your Honor. Simple cases that simply state that the company and the directors are two distinct individuals. Your Honor, it is within the power of the ODPP to prefer criminal charges against the company. Your Honor, you note that a limited company cannot have one shareholder director. Then, Your Honor, why is the accused person being singled out? Is it not right, Your Honor, that the company be held liable, that the company itself be held liable for the actions that are perceived to be its own, for a transaction that was conducted on behalf of the company by the director in the ordinary course of business? Your Honor, to charge my client in his personal capacity is an affront to the principles of company law on issues limited liability. And Your Honor, it is my submission that the same is a fraudulent attempt at piercing the corporate veil to hold him personally liable. And in conclusion, Your Honor, I will conclude by saying Kryptonite International Limited is a going concern that is still actively engaged in the manufacture and sale of electronic appliances, Your Honor. And the debt, or the alleged debt, can be recovered from it. How much of that?
Yes, Your Honor. The state is opposed to the notice of motion dated 9th July 2025 that is supported by a further affidavit dated 4th of August 2025 and in which the state filed grounds of opposition dated 30th July 2025. Your Honor, in the first hearing of my argument on ground 1, the state is challenging the jurisdiction of this honorable court to interpret the issues that have been canvassed by the applicant. And in itself, we do argue that the powers donated to the respondent in this matter, that is the ODPP office, is premised under Article 157, in which it has the powers to institute charges, can as well take over where criminal charges have been instituted in courts, and authorize investigations, among others. On the same thing, the respondent appreciates that the grounds that have been pleaded by the applicant relates to the functionalities of Article 157, which the respondent do submit that interpretation of Article 157 lies under Article 165 of the Constitution, in which the High Court has the jurisdiction to impeach and attack any violations arising from Article 157. Your Honor, I humbly do submit that this court lacks requisite jurisdiction to impeach the respondent with regards to the provisions of Article 165, in which those powers would lie in the High Court. And further, when you consider Article 23 of the Constitution, it lays bare the procedure in which a person that is claiming violations of rights is supposed to approach the High Court with regards to seeking redress. As such, Your Honor, I do submit that this application be dismissed, since the court lacks the requisite jurisdiction, and we do urge the Honorable Court to put down its pen, since it lacks the requisite jurisdiction on the matter. Your Honor, in the most unlikely scenario, the court admits jurisdiction on the matter. We, under ground number 2, we are urging the Honorable Court that the application before court does not meet and has not pleaded any grounds to reject the charges preferred against the applicant in this matter. This is in line with sections 89 and section 134 of the Criminal Procedure Code, which would ordinarily talk about the form in which a charge sheet has been drafted. I will allude this court to the principle of legality. Your Honor, you'll appreciate that the charges preferred before courts are charges known in law, and further, there is a sentence prescribed to the same. And as such, Your Honor, we do urge the Honorable Court to reject the invitation by the applicant to reject the charges before courts. And under ground number 3 of our arguments, we do urge that under Article 157, the respondent is granted powers to institute charges and undertake criminal proceedings the way it did. And if there was any pleadings, if there is any pleading from the applicant that would seek to interfere with the discretion of the respondents, the same should be addressed at the right forum, as we had submitted earlier, that is in the High Court. Under our ground 4, we are guided by sections 193A of the CPC, in which courts have held that matters criminal and civil can proceed concurrently if facts disclose that in the way of a civil dispute, a criminal act was committed, and we do submit with regard to the matter before court. We do agree with us, Your Honor, that we have disclosed that indeed a civil and a criminal act were committed in the same transaction. Under our ground number 5, Your Honor, we do submit, when you go through the notice of motion that has been pleaded by the applicant, you realize that those matters are matters of fact. They are disputed facts, which ordinarily would lie during a trial and would probably form a possible defense when this matter comes up of hearing. So it cannot be argued that it is the interrogatory matter, and as such we do urge that you reject that argument by the applicant. Lastly, Your Honor, we do submit that by dint of section 135 of the Criminal Procedure Code, the only redress would have lied if it is demonstrated by the applicant that the charges before court should be rejected, and in such rejection, Your Honor, you do appreciate under section 135 that the Honorable Court has, in order to expedite substantive justice, it can as well order an amendment of the charges, and as such, we do urge the Honorable Court to reject the application before court. And finally, the council has argued about piercing of the incorporate veil with the locus classici case of Salmon versus Solomon. However, Your Honor, we do urge you not to be invited to that arena, noting this is a criminal matter in which a decision has already been arrived following evidence that was disclosed against his clients. And as such, my Lord, Your Honor, we do urge that the application before court be dismissed and the matter proceeds for pleading. That's it.
Perhaps in a quick rejoinder. The Landed Prosecutor Council raises the issue that the facts that we are raising can form part of a defense and should not be heard preliminary. However, Your Honor, he still on the same breath goes ahead and raises an issue saying that that we must demonstrate to the court that the charges must be rejected under section 89(5) and 134 of the Criminal Procedure Code, which, Your Honor, at the end of the day raises an oxymoron. And Your Honor, on the basis of that, we'll be asking that you consider the facts as proper preliminary issues that are already on record. Furthermore, Your Honor, the application cuts in to the issue of who is the proper person to stand trial. Is it the company or is it the director? And Your Honor, these are preliminary issues that cannot be determined at the time of trial. It's imperative, Your Honor, that the proper party be charged. Even if it's through an amendment of the charge sheet, Your Honor, that's one part that I agree with the Landed Prosecutor Council. That we may be able to conclude on all these preliminary issues before we proceed. Your Honor, second, lastly, Your Honor, we have not raised any issue regarding human rights. That is not an issue before the court, Your Honor. Your Honor, there is a basic tenement of constitutional law whereby the Constitution is a general piece of legislation. Your Honor, perhaps we can refer to as lex generalis. And Your Honor, the Constitution cannot act on its own. It needs statutes to breathe a soul and a spirit to bring to life the various provisions of the Constitution. And Your Honor, this concept is known as lex specialis because the statutory law, for example, Your Honor, the Penal Code is special for matters of criminal law. The Criminal Procedure Code guides this court on how to bring about or how to interpret the provisions of Article 157, Your Honor, and other provisions that have been raised on 165 or 167, Your Honor. We are not arguing that the accused person's rights have been violated. We are simply arguing he is not the right party before the court. We are arguing that the charges that have been preferred, Your Honor, they meet the threshold of dismissal under section 89(5) and 134 of the Criminal Procedure Code, Your Honor, which provisions were explicitly drafted to prevent an abuse of the criminal code, of the criminal procedure, to frustrate individuals, in order for specifically matters like this, such as debt collection. Your Honor, in conclusion, I would state that I remember a lesson from my constitutional teacher, one Mr. Alan Odoe. Your Honor, he actually spoke to something that is happening here today. Your Honor, the penal code is so widely written to allow the provisions to arrest every ill in society, Your Honor, which leaves it open to all manner of misinterpretation, Your Honor. Your Honor, the crime of cheating is very wide, Your Honor. And Your Honor, from the facts that have been deponed here, it is simply one of those instances where persons are taking advantage of the wideness of the, how the criminal statutes are written in order to arrest these ills in society, to bring about baseless charges that have no use in being in this criminal court. One other reason.
Give me a second. Ninth of September. Ruling.
9th of September is convenient on my part. Much obliged, Your Honor. Thank you. Have a good day.
Alright.
Your Honor, my client is present in court, and therefore